we have to delete, two Floyd motions. So let's get going. One of them's quite short, one's a bit longer. Right, so this is Floyd Wallace's motion to strike defendants' reply to their motion to stay discovery, or in the alternative for leave to file a SIR reply in opposition of defendants' motion to stay discovery. Introduction. I, Plaintiff Floyd Wallace, move this Honourable Court to strike the defendants' reply to their motion to stay discovery, or in the alternative for leave to file a SIR reply in opposition to defendants' reply, pursuant to Local Rule 7-2 (b). This motion is made and based on the attached memorandum of points and authorities, the pleadings and papers on file herein, and any oral argument allowed by counsel at the time of the hearing. The SIR reply, if granted, will be no more than 8 pages and cover only issues newly raised in defendant's reply. Memorandum of points and authorities. A. Improper to raise new facts and different legal arguments in reply papers. See Local Rule LCR 12-A(A)(3), which states, a reply brief may be filed and served within 7 days from the date of service of the response. The reply brief must only address arguments made in the response and their citations. Here, everything raised in defendant's reply are unrelated to my opposition to their motion. In my opposition, I only raise that this court can assess the merits, I think that should be, because defendants' motions for dismissal are not fully briefed, not all claims fail, and leave will be granted where a claim fails due to pleading failures. Further, expense does not warrant a stay of discovery. Instead of addressing arguments in my response, defendants instead raise that there are potentially dispositive motions of all claims. Additional discovery is not necessary. A lack of reasonable suspicion, excessive force, lack of probable cause to arrest, and custodial arrest versus citation. Finally, as per their usual behaviour, they misstate the law and facts. Another local rule allows this court to strike the defendant's paper since it was filed in violation of local rules and the federal rules of civil procedure. A. Potentially dispositive. Defendants argue that both defendants' motions to dismiss request dismissal of all claims. Wallace does not contest this fact. Defendants misstate the facts. I have not yet responded to the second defendant's motion to dismiss, and so they don't know whether I contest it or not. B. Additional discovery is necessary. Defendants argue that no genuine issues of material fact exist. This is impossible when I allege that a gun was pointed at my head and defendants argue otherwise. This is impossible when I allege that I did not attempt to trespass and defendants argue that I did. This is impossible when I allege that I was arrested simply for exercising my First Amendment rights and the defendants argue otherwise. Since the district attorney found that there was no probable cause to charge me for any crime, it is very likely that there is evidence relevant to this case in the possession of defendants. By continuing to claim that this court can simply rely on my video of the arrest, this court should infer the existence of additional evidence in defendants' possession that they don't want shared, because it will further show not only their tortuous and criminal behaviour, but also a policy and practice of said behaviour. Defendants first tried to say that the video showed that the gun was never pointed at me. After I referred to a point in the video when it was clearly pointed at me, defendants now argue that the gun was never pointed at my head. It is already clear to me that the gun was pointed at my head, and my expert and the jury will also believe that it was pointed at my head. The defendants have other vantage points of the incident on video and could have the best evidence. You've got their body cam, Floyd. Defendants also have video footage in front of the substation that could be the best evidence. I have had not a chance to depose witnesses. Discovery is a valuable right and should not be unnecessarily restricted. And citation. Although defendants might want to restrict discovery, they have not shown that complete restriction is necessary and have cited no authority to justify it. C. Lack of reasonable suspicion. Defendants state in their reply, Wallace's complaint and video confirmed that he travelled to an LVMP LVMPD substation, put on a mask, and then began to act suspiciously by approaching secured areas and filming. This admitted behaviour certainly justified the officer's decision to detain Wallace. In fact, Wallace did the same thing at a Texas police station, and the Fifth Circuit found his claims untenable as a matter of law. And there's reference to Wallace's own case. Reasonable suspicion existed to detain and probable cause existed to arrest Wallace when he was filming outside a Texas police station and avoiding the police. This is false and not supported by the record. Neither the video or my complaint show a mask or the donning of a mask after I arrived at the substation. The video further shows that I was wearing a mask to avoid being infected by COVID. Hang on. Well, so in one sentence he says video doesn't show, and then he admits wearing a mask. Neither the video nor my complaint show that I was acting suspiciously other than by exercising my First Amendment rights while being black, which is not the suspicion of a crime. The reason why one can approach a secured area is because the area around the secured area is not secure. This is also true for prohibited areas. This circuit has established that one has a clear right to record police activity from a public area, and that a state statute cannot be enforced in such a way as to violate that right. And there's a well-known case for Dice v. Seattle. The defendants mistake the summary of the Wallace v. Taylor case. That case found that there was probable cause to arrest someone under Texas's version of evading arrest statute. If one walks away from an officer after the officer has said to come here, the arrest was not related to filming the police, nor did the court weigh whether the statute was being enforced when normally it wouldn't be against others in retaliation of the exercise of civil rights. That is not what happened in this case. Texas evading arrest statute is irrelevant to the instant case. D. Excessive force. Although defendants originally said that the gun was never pointed at me, I pointed out a place in the video where it was clearly pointed at my head. Now the defendants finally admit that the gun was pointed at me. Defendants now argue that the gun was not pointed at my head, and so it clearly doesn't match the fact pattern of, and there's a citation. I still believe that it was pointed at my head at least once, and the video shows that. I do admit that my complaint only shows that the gun was pointed at me in a threatening manner, and I've asked for leave to amend where that makes a difference. However, even if this court decides that the fact pattern doesn't match with Robinson, defendants are the ones relying on that case. Defendants say that if the facts don't match the specific case, then it can't be excessive force. However, it's clearly established that merely pointing a gun at a person is excessive force, which defendants don't cite. There's various cases cited. E. No probable cause. Defendants argue the officers arrested Wallace for attempted trespass. And there's the statute in Nevada. Here Wallace's video confirms he went onto the LVMPD property to vex and annoy its occupants and to provoke a police encounter. Undeniably, probable cause existed. I deny that probable cause existed. Here defendants admit that the exercise of my civil rights was vexing and annoying to them. They further argue that I had the intent to do it and to provoke a police encounter. I can't make a police officer violate my rights. It was only my intent to test my civil rights, and the defendants failed that test. Defendants must prove intent in front of a jury. It's clearly established that the First Amendment protects criticism of police officers, which may be annoying or inconvenient. Citation. Which also states that a police officer should be immune to annoyance even by fighting words. Citation. Defendants now argue that they enforced this section of the statute even though they knew it shouldn't be interpreted to chill my civil rights. I further argued in my complaint that even if the police had probable cause, the law was enforced in retaliation for my exercising my rights, where it wouldn't normally be enforced. There's that Neves v. Bartlett. Additionally, the individual defendants have not alleged that they were the owner or occupant of the property. LVMPD, as a political subdivision, can't be annoyed or vexed, especially by its people exercising their First Amendment rights. The facts show that the property is owned and occupied by we the people, of which I am a member. Further, defendants cite subsection A of Nevada revised statute, which is not the penal code that was on my citation, nor is it what defendants have argued in their past pleadings, given them probable cause. They've been arguing subsection B, that I had attempted to enter a prohibited area that was clearly posted. Although a person can be charged with additional crimes than they were originally arrested for, the officer can't go back in time and find probable cause where it didn't exist. Probable cause is based on the knowledge of the police officer at the time of the arrest. Citation. Defendants do not allege that the owner or occupant of the building was vexed, and evidence supporting the allegation does not appear in my complaint or on the video. Further, developing probable cause for an attempted crime is harder than for evidence of an actual crime that has occurred. Defendants would have needed evidence tending to show that I had formed a specific intent to go past the gate, but that my attempt to do so was ineffectual. I had been standing still for a while when the gate started closing and had no intent to pass into the restricted area. Defendants have alleged no intent or offered any evidence of it. I would have had to be moving so fast in the direction of the prohibited area and close enough to the prohibited area that only due to my running into the gate or tripping or an officer tackling me prevented me from doing so to have probable cause for attempted trespass. Citation. None of that happened. Further, intent is a fact-based determination for a jury. The police told me that I was being detained for reasonable suspicion, which does not articulate reasonable suspicion of a crime. I was later told that I was detained for the suspicion of auto burglary, even though I was on foot and no longer on the property. No reasonable officer would have believed that an investigation needed to happen into whether I had burgled a vehicle. Defendants further claim that they had probable cause to arrest me for failing to identify. Defendants specifically say that this is a violation of a Nevada revised statute, obstruction statute. Every person who, after due notice, shall refuse or neglect to make or furnish any statement, report, or information lawfully required of the person by any public officer, or who, in such a statement, report, or information shall make any willfully untrue, misleading, or exaggerated statement, or who shall willfully hinder, delay, or obstruct any public officer in the discharge of official power or duties, shall, where no other provision of the law applies, be guilty of a misdemeanor. This is another statute that requires willful conduct. I have not alleged that I intended to delay an investigation in my complaint. This court cannot determine from the video whether I acted willfully or whether a reasonable officer could have determined that I was acting willfully. It is a determination for the jury. Here, defendants don't point to a specific part of the statute. There have been no allegations that there was any statement, report, or information that I was lawfully required to provide. The Supreme Court of Nevada has determined that due notice means 5 days and citation, but the plain language certainly means that notice, including a due date, shall be provided. In the instant case, the officers agreed not to arrest me if I provided my driving license under the threat of arrest, which was done. So the due date was met. There were no allegations that I made untrue or misleading statements, or that I willfully hindered the officers. It's been clearly established by the US Supreme Court that an obstruction statute is unenforceable if it doesn't require a physical act. Not assisting in the officer's investigation is not a physical act. There's another well-known case, Houston v. Hill. Defendants further state, Wallace admits in his video establishes that he impeded the officer's investigation by failing to identify himself for over 3 minutes after being asked to do so. Principles of Terry permit requiring a suspect to disclose his name during a Terry stop. Therefore, at a minimum, probable cause also existed to arrest Wallace for obstruction. The fact the officers did not arrest Wallace for obstruction is irrelevant. Citation. Because the probable cause standard is objective, probable cause supports an arrest so long as the arresting officer has probable cause to arrest for any criminal offence, regardless of their stated reasons for the arrest. Terry does not require a suspect to disclose his name. In fact, it says that a person detained is not required to answer any questions. The issues raised in Hibble is actually Nevada Revised Statute 171.123(3), not 197.190. Hibble at 180 makes it clear that probable cause to arrest someone for failure to identify requires that the identification must be related to the circumstances justifying the stop. Where establishing an identity would establish or negate any connection with the original crime, which clearly does not apply in the instant case. The failure to identify statute can't be used to obtain an arrest where the initial stop failed to yield sufficient evidence. This makes defendants' reference to F.UK.T clearly an incorrect interpretation of the law. The fact that the officers continue to use this statute to try to support arresting people where their probable cause otherwise fails shows a clear pattern and practice of violating people's civil rights, and in a way that is clearly established. Again, Hibble. Defendants further claim that there was a warrant for my arrest, but there is no evidence that a warrant exists or what it was for, and the video shows that even if there was a warrant, the police did not have the jurisdiction to arrest me for it. The police could have possibly detained me for it. It's like the defendants and their counsel don't know how out-of-state warrants work. F. Custodial arrest v. citation. Defendants argue that the citation allows them to arrest me for even a very minor criminal offence in their presence without violating my rights. Defendants fail to defend my complaints under state law, as well as my complaints related to retaliatory arrest. Since Nevada state law does not authorise a misdemeanor arrest, and the LVMPD's policies don't allow it, my arrest then, where not normally done, was clearly done for retaliatory reasons. Even if probable cause did exist, here it did not exist. I'm almost certain that Floyd is wrong on the arrest requirement. I think if a misdemeanor is committed in police presence, an arrest can be made. And I believe they can also arrest for a misdemeanor if between the hours of 7 a.m. and 7 p.m. They're not allowed to arrest for a misdemeanor if it's committed after 7 p.m. and before 7 a.m. unless it's in certain categories. One of those categories would be the offence committed in front of a police officer. There are other exceptions. I think he's wrong on that. This court may allow leave to file a surreply. Courts in this district have allowed surreplies to address new matters raised in a reply to which a party would otherwise be unable to respond. There's citation. Defendants have raised several new issues in its reply, which I cover below. Below? Where are they covered below? Above, do you mean? Because the conclusion is below. Conclusions. Conclusion. Accordingly, plaintiff respectfully requests this court to strike defendant's reply to their motion to stay discovery, or alternatively grant me leave to file a surreply. Signed by Floyd Wallace. Right, on to number 2 of the day, and this one's a short one. And this is plaintiff's objection motion for district judge to reconsider plaintiff's motion for clarification. Introduction. I, plaintiff Floyd Wallace, moves this honourable court to clarify its order from September 15, 2023. Alternatively, I object to the magistrate judge's order. Pursuant to local rule and US code, I object to the magistrate judge's order and request a de novo review of the record. This motion is made based on the included memorandum of points and authorities, the included request for a judicial notice, the pleadings and papers on file herein, and any oral argument allowed by counsel at the time of the hearing. Memorandum on points and authorities. The order includes the following sentence. If a motion to stay discovery is filed by that date, discovery will be stayed on an interim basis pending resolution of that request. I interpreted this to mean that the magistrate judge had incorrectly interpreted the law that a motion to stay takes effect while the motion is pending. Defendants, in their refusal to participate in a Rule 26(F) conference, have stated that they have interpreted it to mean that the magistrate judge made an order staying discovery that would take effect if a party filed a motion to stay discovery. A motion to stay does not stay anything until it's ruled on in the affirmative, and there's citations. Conclusion. Accordingly, plaintiffs respectfully request this court to clarify that this order hasn't stayed discovery, or remand this decision back to the magistrate judge with direction, or for the district judge to reconsider the record de novo. And again, that's signed by Floyd Wallace. Thanks for watching.